Hello and welcome to the U.S. immigration news. Something serious is happening this month, and it's shaking the immigration community from coast to coast. USCIS and the Department of State have quietly rolled out new denial protocols and hard stop restrictions that could change how future visa and green card cases are handled. These changes, first noted in internal agency memos and confirmed by immigration attorneys in early November 2025, are already resulting in more denials, unexpected case closures, and tougher reviews at both USCIS and U.S. consulates abroad. In this video, we'll explain what these new denial rules and hard stop restrictions mean for visa and green card applicants, how they're affecting ongoing cases at USCIS and NVC, and what steps you should take to protect your application from being refused under the new system. If you are liking this video, please hit the bell button, subscribe, and like it so that you may get updates straight to your smartphone. Now let's get into the video. Over the past few weeks, a quiet but powerful change has been taking shape inside USCIS and the Department of State. Multiple field offices and embassies have begun enforcing a new set of case closure and denial triggers, rules that instruct officers to issue denials without further warning once an application crosses certain error, timeline, or documentation thresholds. Until now, most applicants who made a small mistake, missed a document, or failed to respond to a request for evidence could still reopen or correct their case. But under the new hard stop policy, officers are no longer required to issue a second chance notice if the applicant fails to meet updated criteria or timelines. Once your case hits a stop condition, it is automatically denied or closed, with little to no opportunity to reopen it. According to internal updates cited by immigration attorneys, this policy is part of the Department of Homeland Security's effort to restore adjudicatory efficiency and integrity. Language that sounds procedural, but its effect is severe. It's cutting short thousands of applications that in past years might have been given the chance to fix minor issues. For example, a family-based I-130 petition missing one supporting document, or a green card renewal missing proof of residence, might previously have triggered an RFE or a notice of intent to deny, allowing the applicant 30 to 60 days to respond. Now many of those cases are being denied outright. USCIS officers have reportedly received internal guidance outlining automatic denial thresholds, including failure to respond to an RFE by the due date with no grace period, submitting incomplete medical exams or unsigned forms, missing initial evidence that is considered required at filing, filing petitions with outdated versions of forms or incorrect fees. In the past, small errors like these could be corrected through refiling or service requests. But the new system, effective as of November 1, 2025, locks out certain case types once they reach that hard stop stage. The National Visa Center, NVC, is also following a parallel process for immigrant visa cases abroad. Under the revised policy, NVC has begun issuing termination notices to applicants whose cases remain inactive or incomplete for more than 1 year. These were already part of older immigration law, but now they're being enforced much more aggressively. Families that delay submitting financial or civil documents are finding their cases cancelled completely, with no reinstatement possible unless they refile from scratch. At U.S. consulates, similar trends are emerging. Officers are now instructed to apply stricter discretion when assessing document validity and applicant eligibility, especially under the public charge and financial sponsorship rules. Consulates in Manila, Mumbai, and Ciudad Juarez, 3 of the busiest visa posts, have reportedly started rejecting cases that fail to meet new verification thresholds, particularly for sponsors whose income is close to the poverty line. These denials are not isolated incidents. They are part of a broader internal shift towards stricter enforcement, what many are calling a quiet backdoor policy change that doesn't require new legislation. While no public statement has been released, data trackers show a sudden spike in I-485 and I-130 denials during the last 2 weeks of October and early November. Attorneys say the pattern mirrors earlier moves under the Trump administration, where USCIS adopted a no RFE policy that allowed officers to deny cases without giving applicants a second chance. The same logic seems to be returning, though with updated digital enforcement tools that make the process faster and more automated. The impact is being felt most heavily by family-based applicants, humanitarian petitioners, and green card renewal seekers. Applicants who rely on RFES to fix incomplete submissions are now finding those opportunities disappearing. Employment-based and investor categories are not immune either, especially when documentation doesn't meet the updated evidence formatting or digital upload requirements under the USCIS system. So what exactly is a hard stop? In plain language, it's a point in your case where the system automatically halts all processing and flags your petition as deniable without appeal. Once your application hits that stop, usually due to missing data, outdated form versions, or missed response deadlines, officers can deny it immediately. The case cannot move forward or reopen, even if you later submit the missing evidence. For many, this means starting over from zero. Filing fees, biometrics, and months of waiting are all lost. Even though these rules are framed as administrative efficiency measures, their real-world impact is harsher. Faster denials, fewer rejections being reconsidered, and more applicants being forced to reapply, paying full fees again. Immigration lawyers are calling it denial by design. Meanwhile, the Department of State has confirmed that similar hard stop enforcement is now live across most consulates. Visa officers are authorized to suspend or deny visas on the spot if they find that any supporting document is invalid, inconsistent, or missing, even minor errors like mismatched names between forms and passports. In short, 2025 has become a year of stricter reviews and reduced flexibility. Applicants who once had room to fix mistakes are now under a zero-tolerance system. But there is a way to protect yourself. Here's what attorneys are advising applicants to do now. First, double-check every form before submission. Make sure you're using the latest USCIS form version and fee schedule. Second, submit all required initial evidence up front. Don't wait for USCIS to ask. This includes tax transcripts, proof of lawful entry, medical exams, and updated I-864 affidavits of support. Third, respond to any RFE or notice immediately. Don't risk missing a deadline, even by a single day. Under the new rules, late responses are not accepted and your case could close automatically. Finally, track your case regularly online. Many applicants don't realize that USCIS updates its internal actions before sending physical mail. Checking your account daily can alert you to any upcoming issue in time to react. Immigration experts are warning that these hard stop denials may continue expanding into 2026 if not challenged. The administration argues it's about efficiency, but for thousands of applicants it's about survival. One missed email or outdated form could mean losing years of progress. For families and workers navigating the system right now, the best defense is preparation. Submit everything completely, early, and correctly. Because in this new system, even small mistakes can bring your journey to a sudden stop. That's all we have for this bulletin. The U.S. Immigration News Channel provides all necessary visa information and procedures for your U.S. immigration journey. It is important to understand the United States immigration processing steps, visa application requirements, processing times, forms, fees, and more. We will continue to provide all information about U.S. visitor visas, such as B1 and B2, work visas such as L1A, L1B, and H1B, student visas, green cards, immigrant visas, EB1, EB2, EB3, EB4, and EB5, and family immigrant visas. If you haven't already, please subscribe to the U.S. Immigration News channel. Thank you for watching, and we'll see you in the next video.